Welcome to today's program titled Return to Business, Serving Customers with Disabilities While Implementing COVID-19 Safety Measures. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining the CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for the CLE credit. Copies of the webinar recording and materials will be distributed to the attendees in the days following the webinar. At this time, I would like to turn it over to Minh Vu. You may begin.
Well, good afternoon, everyone, and welcome to our program about how to serve customers with disabilities while implementing COVID-19 safety measures. I am Minh Vu, head of the National ADA Title III team here at Seyfarth Shaw, coming to you from my house in Northern Virginia. I am very pleased to have with me live from their respective homes the other two partners on our team, Christina Lonnie from our Sacramento office and John Egan from the New York office. We're particularly excited to bring you this program today because it involves issues that many of you are facing right this minute, and we hope that it will be helpful to you. In fact, our inspiration for this program were the many questions that our clients have been asking us, as well as the safety precautions that we have personally observed while going about our business, shopping and doing things at essential businesses. When we looked into these issues, we realized that very few other law firms had actually focused on these issues, and that there is a serious gap in information and guidance, hence today's webinar. So we hope you'll find it, useful and helpful to your, business and your reopening practices. Now, one thing I do want to make clear is that the purpose of this webinar is to highlight the issues for your consideration and not necessarily to give you specific legal advice on your particular situation. As you all know, facts and circumstances matter. So it's very important that you get advice from experienced counsel about what your specific issue is, because there are going to be important nuances that may change the analysis and where we come out. So with that, let's take a look at today's agenda. Okay, first, we're just going to give you a little bit of background on Title III of the ADA. Provide a little legal framework for all the issues that we're going to discuss. Then we're going to launch into physical accessibility considerations and some of the changes that are happening with regard to physical access in connection with COVID-19 that could impact people with disabilities. The next topic, the third topic, will be masks, fever screening, and maintaining social distance. These are really hot topics right now. Evolving by the minute, so we'll try to give you kind of the latest thoughts on those issues. And then we're going to turn to effective communication. In other words, communicating with individuals with disabilities, people who are deaf, people who are blind. How do you do that now in this environment when the rules and operational processes have changed somewhat? We're going to cover websites, apps, and telehealth issues under that rubric. And then the final topic we're going to cover is, basically kind of reductions in seating capacity, how that could impact people with disabilities, companions of people with disabilities, service animals that are accompanying people with disabilities, and the use of employee restrooms by customers with disabilities. And then at the end of all this, we are going to try to save some time for questions. So again, there is a box for you to enter your questions as you think about them. And we will go through and try to answer as many questions as we can, okay? So with that, and here we are, by the way, your presenters. Probably not looking quite as good as in these photos. And I'm going to turn it to Christina, who's going to tell you about the ADA.
All right. Thanks, Minh. And that's what we're going to be talking about all day today. We're going to be talking about, or for the next 56 minutes, we're going to be talking about Title III of the ADA, I'm going to spend just a couple of minutes level setting. For those of you who have dealt with Title III of the ADA before, you probably already know this, but it's a useful reminder to level set because like Min said, while what we're going to talk about today are the issues that we've seen our clients be confronted with, their employees on the front lines be confronted with, but new crazy issues pop up every single day. So it's important to know the rubric or the framework because sometimes there's not a rule that applies and you kind of just have to go back to basics. So if you didn't know, the Americans with Disabilities Act is a federal civil rights law that prohibits discrimination against individuals with disabilities. It's amazing. It's been in effect in the law for quite a while now. And we've all been practicing in this area for quite a while now. I guess that's what makes it seem strange. The time has flown so much. 1990 is when the ADA was first signed into law by President George H.W. Bush. It's important to note that the ADA has 5 key titles to it, 5 key areas that it deals with. We're going to focus on Title III of the ADA. That's the part of the ADA that governs public accommodations, which are essentially businesses that open their doors and provide goods or services to the general public. We have lots of different webinars where we go into detail about what actually qualifies as a public accommodation. If you're curious, let us know. But it's important to note the other titles of the ADA as well, because we do quite often get some crossover questions, especially between Title II, which applies to state and local government activities, and Title III. And then also sometimes you have, employees, as you might hear with respect to the masks, saying that, they don't need to do something because of something the DOJ said, but that would fall under Title III rather than Title I, which is what governs employment relationships. So, like I said, we are focusing on Title III today, which is what you as a business need to do, what the laws you need to comply with in serving your customers, members of the public. A little more background, and this is where we get into more of the nitty-gritty. So what Title III requires public accommodations do is to have facilities, the physical facilities that are accessible to individuals with disabilities. It requires that public accommodations make reasonable modifications to their policies, practices, and procedures when necessary to ensure that individuals with disabilities have equal access to the goods, services, facilities, privileges, etc., that the public accommodations provide. Title III also requires that the public accommodation provide auxiliary aids and services at no additional charge to individuals with disabilities to ensure that the public accommodation is effectively communicating with the individual with the disability. And we will talk about each one of these concepts today as specifically applied to the post-COVID reopening context. Just in case y'all were wondering, okay, well, what happens if somebody threatens to sue me? What happens if we don't strictly comply with these obligations under Title III of the ADA? Well, you could get sued by a private party in federal court or even state court, and if they win, they could recover injunctive relief, which means that you need to fix whatever the violation of law is, and they can recover attorney's fees and costs. It's important to note that there's also some corollary state disability access statutes like the New York City and state human rights laws and like California's UNRRA Act and Disabled Persons Act, and those may provide for recovery of damages or penalties by the individual as well. The DOJ could also come after you with an enforcement action. We haven't seen a whole lot of that lately under the current administration's DOJ, but it is possible. And we've seen actually a whole lot more in the way of individuals threatening to report you to the DOJ, which Min will talk about later. And if the DOJ were to pursue an enforcement action against your business, you risk potentially $75,000 for a first violation and $150,000 for every violation thereafter. Again, injunctive relief, fees and costs, and potentially, damages to a grieved person. So keep those principles in mind. Now, interestingly, even though if y'all are keeping up on post-COVID reopening issues with respect to employees, the Equal Employment Opportunity Commission, which is the administrative agency charged with enforcing Title I of the ADA, which applies to the employment relationship, it has, the EEOC has issued guidance to employers with respect to, how to deal with COVID issues in the employment context. The Department of Justice, however, which is the administrative agency charged with enforcing Title III of the ADA, has not issued any guidance on how public accommodations should apply social distancing and safety measures while maintaining compliance with Title III of the ADA. This is why, these principles that we're going to talk about today as to how to analyze issues as well as the specific issues that we've seen popped up are really so important because, you're kind of left on your own, at least from, the administrative agency guidance standpoint as to how to deal with these issues. And then again, without belaboring the point, because Min made it earlier as well, these are tough issues and, you don't have to go it alone. We're thrilled that we have our nationwide Title III practice here because Min and John and I are quite often on the phone saying, hey, I've got this novel issue for a client, what might apply? And, we even have to hash through things quite often as well. So consult experienced ADA counsel if and when needed to deal with some of these issues. So with that, let's jump into some of the particulars. Min?
Okay, everybody. So we're going to start at the outside of a facility. The first thing I'm going to talk about is basically changes to basically your entrances, right, to your facilities. What I've seen personally is that, a lot of stores are, perhaps redirecting traffic so that if they might have two entrances, now they're just going to use one, and then they use the other one as an exit. So there's a lot of rerouting going on. And with rerouting comes possible accessibility issues because not only do you have to construct your facilities in a particular way in accordance with the ADA standards, but then you have to maintain accessible features as well. That is an independent and separate obligation. So you may have built it right, but you've also have to operate it correctly, right? So let's say you decide you have two entrances or three entrances, but you're really only going to, have one entrance during this pandemic. Well, you have to choose the accessible entrance. You can't choose. So it could be that those other two entrances might be inaccessible because there's a step at the curb, or the route to the entrance might be overly steep. There could be barriers. It could narrow too much because there's some column in the way. In any event, the point is you have to choose the accessible entrance or one of the accessible entrances. You also have to consider whether there is a route to the entrance that is accessible. In other words, the ADA requires you to have an accessible route that connects the accessible parking, if there's parking, to the accessible entrance. There also has to be a route that connects the public right-of-way, like the public sidewalk, to the entrance. Okay, so, and also point to the public transportation stop as well. So there are kind of three different places from which you have to be able to get to the accessible entrance. So you want to ask yourself, if I'm choosing this accessible entrance to keep open, can people get to it, right? And obviously there are a lot of different requirements for an accessible route and an accessible entrance. We have on this slide, the reference to the 2010 standards, section 404. If you want to look at all the requirements for an accessible entrance, if you don't know which entrance at your facility is accessible. And also, there are requirements specifically for routes as well. But some things to keep in mind, like what are the kind of essential elements of an accessible route? The route has to be at least 36 inches wide and clear, with no changes in level or excessive slopes. The change in level could be anything higher than a half an inch, essentially. That's not beveled, because if you're in a wheelchair or if you're using a scooter, it's going to be kind of tough to navigate that change in level. There has to be no excessive cross slopes because somebody might fall off to the side. It can't narrow to more than 32 inches wide for a length of 24 inches. So in other words, your route has to be 36 inches wide, but then it can narrow to 32 inches for a distance of 24 inches. Okay, so it's a pinch point, but it can't be pinched for too long. Something else to keep in mind too is that some of you may be considering, putting in, devices, gates or whatnot that are going to check for body temperature, like it's a scanner, kind of like the thing that you go through at the airport, but they're not looking for temperature; they're looking for other things. So those structures tend to be pretty narrow and may not accommodate a wheelchair. Again, you can only narrow to 32 inches for a distance of 24 inches. Okay, so please keep in mind if you're buying equipment like that, what are you going to, you have to think about what your plan is. Well, is it the case that if there's some person in a wheelchair, you're not going to require them to go through the scanner and maybe have them go through a different process? That may be okay, but then, that process can't be like any more onerous than the other person, than the non-disabled person, right? So those are things to keep in mind. The other thing that that actually just recently came up that I added to this slide is the issue of drive-through service. Drive-through service as being the exclusive means of providing service to customers at this point. So a lot of restaurants are doing that. They're not providing, walk-up service or carry-out service. And the question becomes, well, is that a problem? I mean, because, essentially by doing that, you're not able to provide service to people with disabilities who don't drive. Okay, blind people don't drive. Obviously, certain people with mobility disabilities may not drive as well. So there is an impact potentially on people with disabilities if you're only going to provide drive-through service. This is a fairly novel question. My view is that if this is the only service you are providing to anyone at this point, that it's probably okay, because to require you to have a completely different service like walk-up service, a walk-up window or whatnot would be a fundamental alteration of the services that you're providing today. Okay, but having said that, again, it's something we want to think through, but I want to flag it as a potential issue for you. Personally, I think that you can't provide service, walk-up service in a drive-through because it's just inherently unsafe to have pedestrians standing in a drive-through lane with cars that are scooching up every minute or so. It's very dangerous. But in any event, if you have this issue, obviously just pause and think about it, right? Because it is something that we have actually seen. Okay, so back to facilities for a minute. Some of you may be considering closing some of your parking facilities just to manage capacity. So to deter people from deter too many people from showing up and standing in line and things getting out of control. So if you're going to close parking facilities, please keep in mind that you have to keep the requisite number of accessible parking spaces. Okay, so in other words, there's a chart in the 2010 standards, section 208, that tells you here are the number of accessible spaces that you need, for X number of, in a parking lot with X number of spaces. All right, so it's a chart. It tells you how many you need. So if you're going to reduce your capacity, then you need to go to look at that chart and decide, okay, my reduced capacity is now this, and then how many accessible spaces do I need, and am I providing those in this modified parking area? Okay. You also want to consider whether the route from the remaining accessible parking spaces to your entrance is accessible. I mean, I'm assuming it probably is because it should have been done that way in the first place, but you never know. Some weird scenarios could come up. So again, just please take a look at that. The other scenario, which is probably fairly unusual, but I just wanted to bring it up briefly, is sometimes we have facilities that have self-parking that is not accessible for vans. In other words, van accessible parking requires a certain amount of overhead clearance, and a lot of parking structures don't have the overhead clearance. So basically, there is no van accessible space in the self-parking. And one of the workarounds that some businesses have adopted is to say, okay, fine, we're just going to, the people who need the van accessible parking spaces are just going to get free valet parking, right? We have valet parking. We're going to provide them with free valet parking. The valet parking people will put their vans close to the front entrance. They'll park it someplace convenient, and that'll be our way of taking care of this problem. Well, if you're doing that and then you decide, you know what, we're not doing valet parking anymore during the pandemic because people don't want like random strangers in their cars. In that case, now you don't have van accessible parking anymore, and you need to think about how you're going to deal with that. Okay, so I just wanted to flag that as an issue for the small number of folks that might be doing that. Okay, now we're going to talk about queue lines. So here, many businesses are obviously creating new waiting lines or queues for people to wait to enter the stores because they're limiting capacity, so you can't have a zillion people in the store. You want to make people wait outside to get in. So the biggest issue with queue lines is ensuring that there is enough space in the line for wheelchair and scooter users. Okay, those individuals need 36 inches of clear width in order to navigate through the line. And when I say 36 inches, I mean in between the bases at the ground. Okay, so not the posts, because even if those are 36 inches, the bases are going to interfere and narrow that scope further, narrow that line further. So you have to measure 36 inches at the base. Okay, now that can lead to, as you can imagine, like a massive amount of space being required for your queue. So what you could do as a workaround is you could create kind of the regular queue line for non-disabled people, and then you could have a separate line that's very short that just goes directly to the entrance with an ISA symbol that is the appropriate width, and then you mark it as the accessible line, and then you allow people with disabilities to use that line instead of the regular line. Now, I know you all are, the wheels are turning. What about, fraud? What about people who just claim they can't use the, they're claiming fraudulently that they have a disability that allows them to be in the line. Well, that's definitely a concern, and you're not really supposed to be probing about you're not supposed to be asking questions about people's disabilities, particularly in the public accommodations context. So you could limit the line, that special line, for people who are clearly have a mobility disability, right? Because they're using a mobility device like a wheelchair, a scooter, a walker. People who have parking placards, accessible parking placards, that's another one. And just limit it to that. Now, there is a concern though. There are people who might not have any devices, who might have mobility disabilities that prevent them from standing in line too long. Okay, that's a separate kind of issue. It's not about the width, it's about standing in line too long. What do you do with those folks? Well, some of those people may have disability parking placards, so you could let them use the line, the short line, or they might not. And you're not going to sit there and debate like whether or not they truly can stand in line or not. One potential solution is if you don't want to just let them use the shorter line because you're concerned about fraud, you could provide them with a stool or something to sit on while they're waiting. Okay, that's just another way to try to work this. But I think one of the key things is your employees need to be trained to know how to handle this kind of situation, right? I mean, to diffuse a situation, usually the easiest thing to do is just to allow the person who claims that they have a mobility disability to use the shorter line. But we flag that for you, and We can't emphasize enough that your employees need to be attuned to this issue. The other thing I just want to point out here is that if you are creating an accessible queue line, it is 36 inches wide, but if you have a U-turn, you need more space at the bottom of the U, depending on the width of the line. So this is a diagram just to kind of show that point. Okay. Now, the other thing we've seen a lot of would be those floor markers that tell you, like, you should be going in this direction. It's one way. These, I routinely, forget to look at the floor markers. And, but yeah, these are new. It's a whole new shopping experience to only be able to go in one direction down one aisle. But they're all over the place, and it's important, right? The problem is that people who are blind are not going to be able to see these markers at all, right? They won't know where they're supposed to stand in the checkout line or which direction the rows are going in. So what are you going to do about that? Well, as with any kind of visual cue in a store, the normal way to handle this is to provide assistance, employee assistance. In other words, the person is unable to see, an employee is going to assist them and tell them, where the cereal is, right? In this case, which way, which direction are they supposed to be going in? And perhaps giving them an overview of what is going on in the store. Like the north-south lanes are two-way versus the east-west lanes are, one-way. But that's probably not going to be enough. So the need to provide assistance to customers does not go away because we have a pandemic. Okay, it's still an obligation. You just have to do it in a way that obviously preserves the safety of the employee, well, everyone's safety, right? And we're going to talk about that a little bit later in terms of how to provide assistance. But I just want to flag this as an issue. Now, one really interesting solution that has been raised with us that I'd like to kind of share is the use of technology to provide assistance to customers. We typically don't, advocate or obviously advertise any particular vendors, but this particular vendor does have an unusual service that is really helpful, so I'm just going to go ahead and say it. There is a service called IRA that basically provides guidance, like voice guidance, to individuals who are blind. So how it works is the person who's blind can subscribe to this service, themselves, and then they have an app on their phone or they're wearing glasses. And the glasses or the phone, both of them have a camera. And the camera basically delivers an image of everything that's going on in front of the person, the user. And there is a person on the other end watching the same image and giving the blind user a play-by-play of what is going on. Like, you are now in the cereal aisle. You're going in the wrong direction, turn around. Like, literally, they're giving them everything. This is how a lot of blind people navigate, like walk down the street and know whether the light is red or green or read their mail. So as we understand it, businesses can actually contract with IRA to provide this service while the guest is in the facility owned by the business. So the moment they walk into the store, they can use the app that they might already have installed on their phone, and then the service is free for the time that they're in the store. Okay. We know a couple of major national retailers that already provide this service. And what that does is it basically virtually eliminates the need for you to have any employees, actually to help these people, because they're all using this app that you have, or this service that you have provided in the store. So it's actually pretty cool technology solution. All right. Now we're going to talk about one of our really hot and kind of hot topics, which is the mask policy. Okay. We've heard a lot about this over the last few weeks from our clients. The first time we heard about it, it was basically a complaint by a deaf individual who reads lips, and basically said, look, I can't read lips when, the employees in the store are wearing masks. Fascinating issue, and it is true. Basically, you can't see the lips and you can't read lips. So that is a big problem. Basically, if you are a public accommodation and you're requiring your employees to wear masks, and I'm assuming that's going to be the case in the vast majority of businesses, you're going to have to figure out a way for your employees to communicate with people who are deaf or hard of hearing. Well, that's true regardless of how they, normally communicate, because some of them read lips, others exchange notes. The point is you have to figure out, okay, how am I going to do this? Exchanging notes is a perfectly acceptable means of communicating in a kind of typical retail or restaurant context where the communications are not very complicated. Okay, it's different, obviously, in a medical setting or kind of in a more involved transaction. So on the exchanging notes front, you could provide pen and paper to both parties, and they will not be sharing those items, obviously. There'll be, or, maybe a whiteboard so they can just, write on the board and then show it, raise it up, and then they can, the person can see while maintaining 6 feet of distance. But you have to think about, well, what's my plan? Like, what if I have somebody who's deaf? How are we going to communicate with them? A new issue that just came up recently also is the fact that if a person needs a sign language interpreter, let's say an individual goes in and is wants to buy a car because it's and is negotiating and all that. Well, maybe let's try even something more complicated. Like, let's say it's a medical visit, okay? And you're talking about a diagnosis. Clearly, in that situation, the Justice Department has taken the position that you need an ASL interpreter, or you need an interpreter if that's what the person, if that's how the person communicates. Well, in ASL interpretation, facial expressions are part of the language. Okay, one gesture could mean something very different depending on what the facial expression is. And if the person is wearing a mask, the deaf person is not going to understand what they're saying. So this is a big issue. So one possibility, and so this is something to consider when you're ordering up an ASL interpreter, is to ask the agency what they're doing about this whole mask problem. In other words, some interpreters are now showing up with the clear head visor, that covers like the whole head, but it's clear so that they can still be seen. But you want to be mindful of that. You don't want the interpreter to show up with a mask and then basically have this thing not work. Okay, so just please be aware of that. And then finally, the other mask policy issue is, of course, customers claiming that they can't wear a mask because of a disability. Now, we have heard numerous reports of people showing up at businesses with these documents like the one you see on this slide, okay, that where it's like made to look kind of official, like maybe this is something issued by the Justice Department or some other official agency. None of those agencies have issued anything on this. So this is obviously some document that's been made up, okay, like been created by, random people who don't want to wear masks. Having said that, the issue of whether a person with a disability can wear a mask is a real one. Okay, so in other words, there are definitely people with disabilities that cannot wear masks. And we need to consider what to do about that. So essentially, if let's say you're going to adopt as a business a customer must wear masks policy, that is essentially considered an eligibility requirement, right? You must wear a mask in order to get service. That policy, we believe, is generally okay if it is based on a legitimate safety requirement. So in other words, the ADA prohibits eligibility criteria that screen out or have a tendency to screen out people with disabilities. Arguably, this could be such a policy, right? But then the ADA says eligibility criteria that are based on legitimate safety requirements are okay. All right, so the question is requiring a mask to be worn in your business a legitimate safety requirement? We're of the view that clearly if the government, if the applicable governmental entity has required, people to wear masks while out, while in public, that is a legitimate safety requirement. And even if your local, state or local government has not mandated that, there is ample guidance from the CDC and other, official organizations, agencies, to support the notion that this is a legitimate safety requirement. Having said that, that doesn't really end. Well, first of all, you want to document why it is that you are applying this eligibility criteria, why you've adopted it, okay? Because it's very important to know, that at the point in time when you decided to adopt this policy, that you had a legitimate basis for it. So you want to document it. Why am I doing this? Then, so now you're going to apply this policy. Well, the inquiry doesn't quite end there, because the ADA also requires businesses to make reasonable modifications to policies, practices, and procedures if necessary, to allow people to get service and goods and services from your business. So is there a reasonable modification of the policy that you can make? That's the next question. Well, probably not, in terms of letting people go inside of your facility with no mask. However, that, again, the inquiry doesn't stop there. Is there then something else you can do to allow people to have access to the goods and services of your facility? In other words, can you do a contactless exchange of goods? People call in, I want X, Y, and Z product. Your employees bring it out, put it outside, and then they pick it up, right? So you need to think about whether there is an alternative to allowing the maskless person inside of your facility. All right. Something to consider. All right. Fever screening.
And Min, just real quick before we move on, based on the videos that we've seen posted to Twitter and social media, one that was circulating yesterday that was actually the day before that was taken actually by the person who was trying to gain access to the store without wearing a mask. And that person videotaped the store manager, come out and talk to her. It just emphasizes, as Min mentioned earlier, and we usually hammer you with during these presentations, is the need to train your employees and have talking points for your employees, because quite often, it's going to be your frontline employees who are going to have to think on their feet and know what to say to these sometimes very angry customers. So having these alternatives already thought out and having talking points is really important.
Yes, that's exactly right. I mean, sometimes you have the right policy, but how it gets implemented or, the explanation for the policy goes awry because your frontline people are not trained, right? So we know that they have a lot to keep up with at this point, new things that they have to learn, but it is really important to kind of cover a few of these big issues. So next we're on fever screening. So some businesses are talking about screening guests for fever before letting them in, and then excluding those that do have a fever. This is definitely kind of a challenging issue because, again, it's an eligibility criteria, as we discussed before, kind of like the mask wearing, and it has to be a legitimate safety requirement. We have looked at we've probably looked at every case involving legitimate safety requirements at this point. And the one takeaway that we have is that the courts really scrutinize cases involving legitimate safety requirements to determine whether they're really that, right? And they expect you to have an explanation for why this is a legitimate safety requirement developed at the time when you implemented the policy, not some after the fact, post hoc justification. So if you're considering doing something like this, please, you really need to shore up why you're doing it, okay, and document it, and then really kind of work through the process of how you're going to do that screening to protect the privacy of the individuals, just to kind of make sure this thing goes as well as possible. Another defense that's related to the legitimate safety requirement defense is the direct threat defense. So essentially, you don't have to allow a person access to your goods and services if by doing so you're going to create a direct threat to the safety of others, okay? And again, can you use that? Is a person with a fever a direct threat to others? I mean, possibly, but it is an individualized inquiry, unlike the eligibility criteria standard. So again, just proceed very cautiously, and really this one, I would definitely recommend that you speak to your counsel about and you evaluate the whole situation, okay? All right, now I'm going to turn it over to John, who's going to talk about maintaining distance.
Thanks, Min. So, we talked earlier about how a pandemic doesn't eliminate the obligation to provide assistance to customers with disabilities, but it may complicate some of that assistance in a socially distanced world. One of the examples we provide here is, for example, if it would be totally appropriate if you have a blind customer to offer an arm to guide that customer to an area of the store. But how can you do that and maintain 6 feet of distance? So employees need to be trained and aware that they may have to proceed in an alternative manner. We talked about IRA. The employee may need to be the one, if you don't have IRA, to provide wayfaring directions for a blind or a visually impaired customer that needs to get to where they need to go. Most of the kinds of assistance that you'd provide, reading labels, reading menus for a blind customer, reaching high products, can probably be accommodated in a socially distanced world. But there may be instances where you're going to have to get creative, and you should flag that for your staff. Next is effective communication. This is a difficult time, and the bottom line is that getting around is problematic for everybody, and probably more so for people with disabilities. So there's every reason to think that more commerce is going to be funneled towards websites and mobile apps. Here in New York, very recently it was announced that the New York City subway system is going to close down for the first time, like ever, for a couple of hours to do disinfecting. Kind of underscores the danger of public transportation on which many people with disabilities rely. You also can't socially distance if you're in the same car with someone. So, there's every reason to think that more people with communicative disabilities, disabilities of sight, hearing, and speech, are going to go online to do what they want to do rather than deal with the challenges of the in-store experience. And so, website accessibility is something most of you are probably familiar with. It's probably the topic that Min, Christina, and I speak about the most because, as a lot of you know, it's an area where there's an intense increase in litigation. Last year and the year before that, there were 2,400 plus federal lawsuits filed. It's certainly an area where we're seeing a massive growth and increase in the number of cases. And it's beyond the scope of our presentation to get into what's an accessible website and all the case law. But the point is that the questions you should be asking is, for our existing website, for new functionality that we're adding to the website, is that content accessible? So for people who are blind and visually impaired, they're relying on screen reader technology typically that converts visual content on the screen into audible form so that it reads the context on the screen, and you can navigate a website in such a way to do it efficiently, because you can't sit there and wait for all of the content on a screen to be read to you. You need to be able to, if you're using a screen reader, navigate with your keyboard and get to where you want to go. So for people with visual disabilities, the question is screen reader compatibility. For folks with hearing disabilities, audible narrative content, video content, the question is that being displayed visually? Is that being displayed through captions? And so these are the kinds of questions that you have to ask, and you should be asking, because we're probably going to see a continuation, if not an acceleration, of website accessibility and mobile app accessibility litigation in the future. We mentioned here accessibility statements. It's very fashionable to have an accessibility statement right now. It's probably a good idea. It is a page or statement on your website that basically indicates what degree to which you are striving for conformance with various accessibility criteria. We're a little mindful, though, that the consultant community, the accessibility consultant community, will oftentimes recommend statements that are not realistic or not accurate. There's really no one-size-fits-all accessibility statement. It's something that kind of depends on you, your business, and where you are. One important thing to note is that you should have a telephone number or an email address of somebody who can provide assistance, because the point is if your website is not fully accessible, you want to provide an alternative means to provide folks with the help that they may need to access that information. Another point we reference on this slide, other technologies. You may be thinking about doing creative things in the stores in order to avoid person-to-person contact, like having kiosks and self-service devices. There are specific requirements for ATMs and fare machines, but not necessarily for certain kinds of self-help kind of kiosks. But the point is, you should be asking, is that going to permit somebody who has a visual or a hearing disability to use that equipment? And are we providing alternative methods? A really hot topic within the general category of effective communication is telehealth. The advocacy community is all over this, specifically the deaf and hard of hearing community. The question is, now that going to the doctor and going to the hospital can be just hazardous in terms of your exposure to COVID, for people who are deaf or hard of hearing, how can they effectively communicate with their medical providers on a telehealth visit? Min talked about the problems about ASL interpreters or American Sign Language interpreters that have masks. Well, there's other practical difficulties. For people who become deaf later on in life, they may not be fluent in ASL, and they may need captioning. So like CART is a type of real-time captioning, kind of like a court reporter, except you're getting the captions in real time. How can your telehealth, if you're operating on a mobile, you have a mobile app, does it accommodate captions? Does it require the person then to have two devices? They may not have two devices to see their doctor on one screen and the ASL interpreter or the captioning on another. How does that work? What about the availability of this service? Min talked about how DOJ has been pretty clear that in the medical context, medical is not retail. Based on the nature of the complexity of that communication, the fact that it's life or death, you need to do more than exchange notes or chat. You need to provide an interpreter or a captioning service. If you're providing telehealth 24/7, and some providers are, then how does it work in terms of getting the assistance necessary to have an effective communication? One option might be remote interpretation. So having what's called VRI, video remote interpretation, having an ASL interpreter at another location and providing those captions, providing that ASL in real time. That's an option to consider as well. So this is kind of an evolving area, but it's an area where, for some folks it's really life or death, and we've already seen some litigation over the accessibility of telehealth. I'm going to do this really quickly. Service animals, we've had questions about whether COVID impacts access for service animals, whether it presents a risk to health and safety. The point is that the CDC has issued guidance and has got out in front on this issue, or not the issue of service animals specifically, but animals and the risk of transmission. 2 tigers in the Bronx Zoo came down with COVID. There's been reports of pets coming down with COVID. So the question is, can we let a person in with a service animal when that may increase the risk of transmission? What the CDC has said is that there's really no evidence that animals play a significant role in the transmission of this virus. The risk of animals contributing to it is low. The CDC also recently said that there's no evidence that the virus can spread from the fur or hair of animals to people. In fact, really, the greater threat is to the animals because they can catch it from us, but there's not as much evidence that it's in the reverse. So there's really not much of a basis to exclude. You're kind of back on your, or rather, you have to kind of rely on the existing requirements and the existing framework for service animals, which is you're very limited in what you can ask when a person has a non-obvious disability. You can basically ask, is that animal required because of a disability, and what tasks is the animal trained to perform? If the animal's out of control, that would be a basis to exclude. If the animal's not housebroken, that'd be a basis to exclude. But generally, the animal is permitted to go anywhere the handler is permitted to go. And we don't think that COVID changes that, although, of course, it's a fluid situation, and that might change going forward. I'm going to hand it off now to Christina, who's going to read you your CLE number, your code, and is going to get into seating.
All right, so are you all ready? The CLE code is SS as in Seyfarth Shaw, or Silly Snake, or Super Bowl Sunday, if that ever comes again. So SS2272. That is SS2272. Okay, so with that, Cielico done, we're going to move back inside to physical facilities again and talk about reduced seating capacity just briefly, and then we're going to talk about bathrooms briefly. And then we've had a lot of questions come in about masks and temperature taking. We know that those are some of the toughest issues. So I'm going to try to blow through these couple of last points here so we can get back and take some of those questions. If you have any other questions, now's the time to submit them so that we can try to get to them before we wrap up at the top of the hour here. So reduced seating capacity. This is an interesting issue in part because seating capacity or seating, accessible seating, period, is an issue that so many of our clients encounter. And I think it's just because, you know, the interior designers or somebody isn't, not to, you know, knock on the interior designers, but somebody's not paying attention and they just order tables that aren't accessible. And then the retailer or the restaurant gets sued for having tables that are not accessible. We're going to show you in a minute what an accessible table looks like so you all know. But the issue that applies or that is arising in the COVID context is if you're trying to social distance in your restaurant, for example, then you might be removing some tables so that people can be sitting 6 feet apart from each other, or whatever the guideline is in your jurisdiction now. So when you do that, you take seats out, but you need to make sure that you are leaving tables in that are accessible. You could perhaps take all your tables out that aren't accessible and only leave the accessible ones, but you need to, at a minimum, when you take the total number of seats that remain in your restaurant, the total number of places where people can sit after you have removed tables or seats, 5% of those total seats need to be accessible. So what does that mean for them to be accessible? Well, they need to look kind of like this. There are other options that you could pursue, but this is the safest way to go. Envision fitting a box under the table, and a box that is of certain dimensions that I'm going to show you on the very next slide. That is the ideal for an accessible table. A pedestal table sometimes can make the grade if it's got the right dimensions, but it's getting risky because you're going to have different parts of the table that are impeding into the required measurements. So here's what you need. You need, 34 high to the top of the table, 27 min to the bottom, 30 inches wide, and 17 inches deep. Remember this picture, pull it up, save it once you get the slides after. This is a really useful visual to have to make sure your tables are accessible. So once somebody's in your restaurant, they might need to use the restroom, but more likely it's if you are a retail store that has maybe made the decision to make your restrooms employee only, especially, I've been reading that that's still an area that's a big concern. How do you keep the bathrooms clean to prevent the spread of COVID? If you're going to make that employee only to try to protect the safety of your employees, it's important to know that, as going back to the beginning of the presentation here, one of the principles of ADA is that you need to make reasonable modifications to your policies and practices to ensure access to individuals with disabilities. So you need to decide whether it would be a reasonable modification to allow individuals that have certain types of disabilities that might require them to need to use the restroom urgently to use the restroom. You also need to think about those couple of states that have restroom access acts adopted that essentially require you to allow individuals with certain types of digestive disabilities to use employee-only restrooms. Those acts provide a little bit more leeway as to what can be asked of the individual. So if you are in one of those states, be careful that if your employees are asking questions to determine whether somebody should be allowed to use the employee-only restroom, that they are doing so with inquiries that would both comply with the limitations the ADA imposes on inquiries, as well as the Restroom Access Acts. So that is the last of our essential principles that we are covering for you. This slide, which you'll get in your deck afterwards, has a link to our blog where we have covered some of these topics in more detail with links to some of the resource documents or the source documents, as well as our firm's COVID-19 Resource Center. But now we can jump back into some of the questions. Min, did you want to take some of the mask or temperature taking questions that came in?
Sure. Let me just scroll down to
scroll through them here.
Okay, here we go. So we have a question. What about the orders that make exceptions for people who are unable to wear masks due to medical conditions? So I think the question is, does that somehow, negate the legitimacy of the safety requirement? Look, I think it's a call that every retailer is going to have to make. In other words, you could choose. There's nothing that requires you to enforce a mask policy for everyone. If somebody says, I can't wear a mask because of a disability, you could take them at their word and not require it. You could require your employees to wear a mask, assuming, again, that they don't have a disability themselves that prevents mask wearing, and that would be fine. I mean, that would be the, more or less risky, I guess, option. On the other hand, that also exposes your employees to greater risk. So you kind of have to weigh that. There was, let me go to another, I think I had another question here. Can you address how that applies in a theater, performance, or museum environment where there is no way to deliver services contactlessly? Okay, so this question also, I think, relates to the mask policy, where essentially there is no way for you to, there's no way you can deliver the services other than to let the person in. Okay, and now are you going to let that person in without a mask? You might consider whether some other, the face shield might be something that you could offer people who might have a problem with a mask. That could be there could be options like that. I think context matters here. If it's a theater, everyone's going to be sitting close to each other, even though they might be 6 feet apart. That feels different to me than, say, a museum where you might be walking around. So again, this is where kind of what I started, when we started at the beginning of this webinar, I said, listen, we're here to flag issues for you, not necessarily solve and answer every question, right? Because we kind of need context matters. So a theater, the answer there could be different than, say, a museum where half the museum is outside. So it's all, but I think we would have to take into consideration all of those factors. You guys want to try a different one? Different question? You or Christina?
Sure.
Dawn or Christina?
Yeah, I think I'm here. One question, Min, that I thought just maybe bore a little bit of reiterating was, what do you mean by document the legitimate safety reason? Is it by corporate? Is it by each store? And, I think it's one thing to think about is it could be by store potentially because different counties, different local jurisdictions, if you're in California counties, have different requirements with respect to mask wearing. So from that perspective, you would want to be documenting, which jurisdictions your stores are in that you're requiring the mask to be worn. You may, though, have a company-wide policy of masks must be worn based on the guidance from the CDC. So there might be other factors as well, but the point is to document what is going into your decision now, because if you get a lawsuit, down the road, you're then going to have to scramble to try to recreate whatever your reasons were for those legitimate safety reasons and implementing those requirements now.
Yep. Right. I think that is really, it's a very interesting question because essentially it just goes to show you there is no kind of one-size-fits-all solution, even for documentation, right? In other words, if you're a company, the policy needs to look at, like, from a national level, the policy, but also potentially what the local requirements are as well. So I had a question that says, here's a question. What about social distancing and reduced seating capacity in a fixed seat situation like a movie auditorium? I'm assuming this question pertains to seating, and in particular, accessible seating. Again, there are rules for, like, if you have X number of seats in the theater, you need to have a certain number of accessible seats and companion seats. So again, I would apply, whatever the reduced capacity is, I would then take that number, look at the chart, and determine how many accessible seating positions I need, and then basically make those available. So that's how I would apply the rule there.
It looks like we are at the end of the hour here, Min. We're at 12 o'clock Pacific, 3 o'clock Eastern, so we probably should bring it to a close. But we see even more great questions coming in. So we should just reiterate, feel free to reach out to us afterwards. Please check out our blog where we keep updates on all of these topics. Any other closing points, Min or John?
Yeah, I wanted to say somebody made a comment here that there are masks with clear sections. Somebody did point this out to us kind of earlier in the week, and we don't know how well those work because we don't know whether they get steamy, whether there's fog, but we do want to put it out there that there are apparently masks that are clear, so you might want to explore that for your employees as well. Okay, we're all here to figure this out together, and any good ideas we're perfectly willing to try out and put out there. John, do you have any closing remarks?
Nope. Everybody.
All right. Well, thank you so much.
Thank you all for attending.
Yeah.
Have a wonderful day, everyone.
Yes, definitely.
This concludes today's webinar. Thank you for attending.